Good afternoon, everyone, and welcome to the webinar, Investigating and Prosecuting Labor Trafficking, Exploitation for the Sake of the Bottom Line. My name is Charlene Whitman. I'm an Associate Attorney Advisor at Equitas, the Prosecutor's Resource on Violence Against Women, and I will be moderating today's webinar. For best use of iLink, please call into our conference line 530-881-1212, passcode 202-731-738, and please call in from a landline if possible. The number and passcode is in the top left-hand portion of your screen for reference. If you are using a mobile phone, please do not use the speaker option. You can also call in and you can also connect using the internet audio on the start page of the webinar iLink session. Please do not call in and connect via internet audio unless you experience technical difficulties, and then please call into our conference line. If you have any technical issues, you can use the iLink hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen. You can also contact iLink directly at 1-800-799-4510. Throughout the webinar, questions will be posed to all participants, and you can respond to those questions by using the iLink feedback indicator located on the left-hand side of your screen. You can pose questions or comments via private chat to me, Charlie Whitman, which I will share with our presenters anonymously so they can be addressed during the webinar. You can also, public chat has been disabled for the duration of today's webinar. However, you can private chat with one another and myself as well. So today's webinar is hosted by Equitas through funding from the U.S. Department of Justice Office on Violence Against Women. Equitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. A handout version of the PowerPoint presentation you are seeing today and biographies for our presenters will be sent via email following the webinar. Prior to joining Equitas, Viktoria Christensen served as the Deputy Attorney General and Special Assistant to the Attorney General of New Jersey. She also served as a Senior Attorney at the National Center for the Prosecution of Violence Against Women and as an Assistant District Attorney in Philadelphia, Pennsylvania. Professor Bridgette Carr founded and directs the Human Trafficking Clinic at the University of Michigan Law School. Professor Carr and her students in the Human Trafficking Clinic provide free legal services for victims of human trafficking, and her research and teaching interests focus on human trafficking, immigration, and human rights. She is a member of the Michigan Human Trafficking Task Force. In 2013, she was appointed to Michigan's first Commission on Human Trafficking by Attorney General Bill Schweit. Professor Carr assisted in the launch of a human trafficking clinic in Mexico and was named a top lawyer by Marie Claire magazine for 2012. I also want to let everyone know that today's presentation is also being recorded for later viewing. At the conclusion of today's webinar, participants will be better able to identify indicators of labor trafficking, collaborate with multidisciplinary professionals to support a victim-centered approach to investigation and prosecution, and to prosecute a case of labor trafficking in an offender-focused manner, and to overcome collateral challenges in order to provide holistic victim support. I'd now like to turn the substantive portion of today's webinar over to Viktoria Christensen.
Good afternoon, everyone. We at Equitas are really thrilled to have the opportunity to present today's webinar with Bridgette Carr. She is really one of just a handful of people in the United States who has this type of unique professional experience with labor trafficking and its survivors. And this webinar will draw from her experiences as well as from anecdotal information and research, significantly from research conducted by the Urban Institute. During this webinar, allied criminal justice professionals and, of course, prosecutors in particular should ask themselves, what are the circumstances in which certain cases do or do not move forward in our prosecutor's office? What challenges do we face? Can we assess those challenges and then develop policies and practices that will help us overcome them? Perhaps the challenges are due in part to the office's internal culture or the office's approach to cases. Does the institution have a culture that responds to certain cases in a certain manner? Are prosecutors wary or even perhaps afraid to try certain cases? And why? Why are they feeling this way? Are offices requiring certain information prior to proceeding with charges or proceeding with the prosecution? Is that information consistent with prosecutors' ethical responsibilities? These are all questions that arise, I think, more frequently in crimes involving violence against women, and we should confront our own practices and perhaps hesitations as we all strive to identify, investigate, and prosecute more labor trafficking cases. We're really just at the beginning of case development when it comes to this crime, which is a stark contrast to the number of potential cases in existence in the United States and certainly around the world.
Thank you, Vicki, for having me on this webinar today and for really focusing attention on cases of labor trafficking. I'm heartened to see so many of the names of people who are attending here are people I've worked on cases with already. So I know that between the presenters and even those who are participating in this webinar today, we have a quite vast knowledge of labor trafficking cases. The definition that we see on this slide here is from the Trafficking Victims Protection Act, and it's the federal definition of labor trafficking. Each state is going to have its own labor trafficking definition, so I want to be clear that we're focusing on the federal definition for purposes of this call. And this is just a definition of compelled service, and the compulsion at the federal level and at most state levels is going to come through force or fraud or coercion. And the fact that that phrase is an or sentence is so important. We see commonly in labor trafficking cases now that the coercion being used by traffickers really is psychological coercion. Traffickers know that if they use physical force that they're more likely to be caught. And so traffickers understand this definition deeply, and so it will help us if we understand how they're using this definition to their advantage. Finally, I just want you to note before Vicki goes through this definition in detail that unlike sex trafficking, there is no difference in the definition of labor trafficking between adults and minors. So this definition applies regardless of age.
So the slide that we're looking at now are just the basic elements in the federal definition of labor trafficking, really illustrating what Bridgette talked about in the previous slide. Labor trafficking is about exploitation, supply and demand. It's a business with high profit and what our traffickers have traditionally seen as low risk. Bridgette mentioned the TVPA, and we just want to remind everyone it's been reauthorized in 03, 05, 08, and 2013. And at this point, all 50 states in the District of Columbia criminalize labor trafficking through involuntary servitude or similar trafficking statutes. Wyoming was our last state to pass a trafficking law in February of 2013. Bridgette also mentioned the term coercion. And this slide shows us the general federal definition of coercion. Subsection C, the abuse or threatened abuse of the legal process, is so important. It's directly tied to witness intimidation, which we'll discuss later in this webinar, and which is relevant in almost every trafficking case, every violence against women case that is going to come to your attention. Coercion, particularly for state and local prosecutors, is such an important statute. It's one that we really encourage every prosecutor, every law enforcement officer to be familiar with, and one that we should be giving more thought to in terms of charging and in terms of understanding how our offenders are committing crimes. So really, although most of the people who are listening are probably working on the local level, and most of our comments are going to be designed and directed towards those working on a local level, I just want to point out here that let's assume that the defendant has no prior record. And if we're talking about the federal statute, the defendant who's going to plead guilty only to coercion related to labor trafficking, and that statute would be 18 U.S.C. 1583A2, enticement into slavery, that defendant would be looking at a max of 20 years. And if that offense was combined with aggravated sexual abuse, and to those of you working in the field, we know how often we hear of rape being used as a weapon against a victim and as a method of intimidating other victims. So if that enticement into slavery was combined with aggravated sexual abuse, that defendant could be looking at up to life. And the same statutory scheme, a max of 20 years, and if combined with aggravated sexual abuse, up to life, would be true for a defendant pleading guilty to labor trafficking under the federal forced labor statute, which is 1589, and also the federal statute that is trafficking with respect to peonage, slavery, involuntary servitude, or forced labor, and that's 1590. And there are certainly other aggravating crimes that would take that max from 20 to life, but I specifically mention aggravated sexual abuse, again, because we hear of this co-occurring with labor trafficking so often. And one more thing to add, just whether these sentences would end up running concurrently or consecutively would be in a judge's discretion.
So where can we find labor trafficking? Where should we be looking for it, and how big is the problem? The International Labor Organization, the ILO, estimates that 20.9 million men, women, and children are subject to forced labor around the world. Of that, 68% are involved in forced labor for labor exploitation and economic activities, such as the ones listed on this slide, and 22% are involved in forced labor for sexual exploitation. So you can see there they define forced labor a little differently than how we think about labor trafficking. On child labor, the ILO reports that the number of children in situations of child labor has declined by 1/3 since 2000, but still stands at 168 million, with 60% of those found in agriculture and more than half involved in hazardous work. Despite the positive trend, 168 million children, more than 1/2 of the entire population of the U.S., are enslaved. As former UN Secretary General Kofi Annan stated regarding child labor, few human rights abuses are so widely condemned, yet so widely practiced. So why don't we see it? Why aren't we identifying more labor trafficking cases? Well, one, it gets significant less media attention in the human trafficking conversation in the United States. It's also difficult because unlike sex trafficking, where you can identify an illegal industry in most parts of the country and focus on that and have entryways as law enforcement for investigations into those individuals, labor trafficking exists in so many industries, most of whom are legal industries. So we often lack sort of the front door into talking to folks. So we have to figure out other ways to find a front door. It's also the case that many traffickers, who are the employers, are really good at creating the kind of documents that would exist in an otherwise valid employment relationship. There's actually a case in the United States, U.S. versus Farrell, where workers from the Philippines were brought to a hotel in the middle of the country at a Comfort Inn, and the trafficker created all the right employment contracts, got the correct visas, and even created fake checks that the victims were supposed to show that they were paid according to according to U.S. laws, even though those checks were never actually given to the victims. They only had the copies of those checks. So it is a tough task that we have to identify labor trafficking cases, but the prevalence of it means that we just have to do it.
So we have a question here requiring our participants' feedback, and the question is, have you been involved in a criminal investigation of labor trafficking that involved one or more of the barriers that Bridgette just mentioned? And you can use the feedback indicator on the left-hand portion of your screen to choose yes or no. And I'll give folks just a few moments to respond to that. And just to let you know that the word barriers here is in quotes just to emphasize that these things can appear to be barriers, but they are often actually aren't once a case and its elements and the law are analyzed. And you can please feel free to private chat me any specifics of the challenges that you have faced or experienced and the results of those challenges or cases. So it does look like about 58% of you have not participated in an investigation, and 38% of you have. So thank you all for your feedback. And please private chat me any other additional responses.
So now let's take a look at some trafficking indicators. Let's see if we can get the slide to go to the next one. Charlie, can you get the slide to go to the next one? Okay, great. Thank you. So I want to talk about some trafficking indicators here, but I want to really make sure that we understand these in context. So the first bubble that you see at the top is forced to act against his or her will, or someone must work against his or her will. That really has to be seen from the perspective of not what someone consented to. It very often is the case that someone feels compelled to consent. So we're not looking to ask the question of, if I ask this worker, are they here by their own choice, or did they agree to these terms? You have to understand the environment around them, were they compelled to consent. There are some cases where the victims would say, no, I did not consent, but I want to really be clear. You can't consent to be exploited. It's, if you are so vulnerable that you would agree to work for $1 a day and work 15 hours a day, yes, you consented to that, but it's still exploitation. There are a number of other things up there on that slide, all important to think about, all things that if you think about them, not only are they indicators, but they often make people vulnerable to be trafficked. Language barriers, not having access to documents, or perhaps have been subjected to violence and threats in the past, makes them more likely to be trafficked in the future. I want to give you one question that we see in our work that's quite helpful in trying to identify trafficking victims, and that is, if you think about asking someone, do you know how to get home? We know lots of times that folks are asked, what is your address? And most traffickers make sure that victims have an answer for that. If you ask instead, how would you get home from here? A majority of my clients would not have been able to answer that question. They would have been able to provide an answer to the question of what is your address, but they didn't have any clue how to get home, often because the address they were given was fake, but usually because they didn't have the power to drive themselves to work, or they weren't ever oriented to their location. In fact, we have clients in the human trafficking clinic who were held in domestic servitude in Michigan, and when found, when asked where they were, said they were in Florida. And if any of you are experiencing the winter that we are here in the north, you know that this is not Florida. Let's look at the next slide. I also want to note that asking the question of whether someone has been paid does not end the inquiry about human trafficking. It is often the case that individuals are paid for some portion of their work, or have a low pay rate, or believe that their pay is being sent home. And so if you believe that your pay is being sent home, but in fact it's not, you would answer yes to the question of are you being paid, because you think that you're being paid. So we have some additional indicators here. I want to point out that many of these indicators often lead us to think about foreign nationals, or people who aren't born in the United States, or aren't from the United States, as being victims of labor trafficking. And our experience is that, yes, that in fact is the dominant model of who is a victim of human trafficking. But we represent, and we know of, U.S. citizens who are victims of human trafficking, and labor trafficking specifically. And so we want to be careful today in this webinar not to exclude the possibility that U.S. citizens could be victims. In our case, it is a woman who was forced to be a drug mule for a pimp who was selling a certain group of women, but was forcing other women to run drugs for him. One thing you want to think about, too, when you're trying to identify whether there is a labor trafficking situation, you'll want to inquire about safety trainings. But another thing to think about is asking about safety manuals and those sorts of things, or are training materials translated into a victim's language. For example, we see a significant amount of exploitation of labor trafficking in the carnival industry, and where the carnivals are going from town to town and putting up rides, and none of the safety manuals or the instructions on how to put up the rides are in the language of the individuals who are putting the rides up. So even though the traffickers in that case said they did all the trainings, if you do it in a language that the victims don't have access to, you haven't done it. It's a good way to try to catch the trafficker in a lie. The other thing you'll want to think about is the amount of work that's getting done, and compare that to the hours that are reported for the work, and ask yourself some questions about, is it possible to get all of that done in a quote-unquote normal work day? We see cases of where the victims are reporting working 8-hour days, and the amount of work they complete, it's almost impossible to get it done in that time, and so that would have been a strong signal to investigators that in fact they're working 16, 18, 20-hour work days. So So let's focus on one component of labor trafficking, which is domestic servitude. We have a significant number of domestic servitude cases in the Human Trafficking Clinic at Michigan. These can be really tough cases for us as victim advocates because we have found they are often the hardest to be prosecuted. And I wish I knew exactly why that was. But I think some of it comes down to that domestic servitude cases are, for the most part, single victim cases. And so they are extremely isolated. So not only are they isolated in that they're often the only victim, but they're isolated within someone's home. They often never or rarely leave, given minimal food to eat, that sort of thing. However, it doesn't mean that if they're allowed to leave more often than what you would expect in a trafficking situation, that they're not being trafficked. Good traffickers have so much power and control over their victims that they know that if they let someone leave for a little bit of time, they will come back and they won't seek out help while they're gone. We should never penalize someone just because their trafficker is excellent at what he or she does. I get extremely frustrated when I hear expectations put on victims, especially victims of domestic servitude, about missed opportunities for rescue, missed opportunities to tell someone what was happening, because what you're really saying is your trafficker was so good at what they did, why couldn't you have been better? And we shouldn't put so much focus on the behavior, choices, and actions of the victims, and instead should put that focus on the traffickers. We should also note that often in domestic servitude cases, what we usually have as central to the case is victim testimony. And so in domestic servitude cases, like all labor trafficking cases, it's essential that if your case is going to rely on victim testimony, you want to make sure that the victim feels safe and secure before doing in-depth interviews. The other thing is that many times in domestic servitude cases, victims believe that money is being sent home to their families, and the discovery that it's not, especially if that discovery comes from an interview with law enforcement, can be particularly crushing. And so you want to take care if you're disclosing that to a victim, but you also want to take care in that in an investigation, because just because someone says, yes, I'm being paid $10 an hour, you need to find out where that money is going and whether she or the family has access to it. Another form of labor trafficking is begging or petty crime. You see this commonly with children or groups of children, elderly persons or disabled migrants. Some signs that you might have this kind of labor trafficking on your hands: children of the same nationality in large groups with few adults, children who live with adults who are not their parents, and large groups of children who have the same adult guardian. You want to think, these are tough cases to crack, I will say. You want to think about questions that could throw off the victims. And I don't mean that in a non-victim-centered way. You want to think about the script that the trafficker would have given the victims, and think about a way you can ask a question that throws them off script so that you might realize they're off script. And one way to do that, especially, we see cases where kids are often selling candy for school fundraisers. And if you pay close attention and if you know anything about the schools in the area, you can ask some questions that you realize that child has no legitimate connection to the school. And so figure out quite quickly that it's not for the local high school that they are selling these trinkets.
So in spite of knowing the indicators, we are not bringing a lot of labor trafficking cases into the criminal justice system, as you can see. This slide depicts findings from an Urban Institute study of 12 United States counties and 3 comparison counties. And although the study is not intended to be nationally representative, because researchers had to use a targeted sample that included jurisdictions that had identified trafficking, it's an important study. Even in those jurisdictions that were already doing trafficking work, researchers had difficulty finding labor trafficking cases. In reviewing closed cases, in talking to allied criminal justice professionals, in looking at cases that could have been trafficking where trafficking was not identified, the researchers found that labor trafficking accounted for only 11% of all identified trafficking cases. 85% of the cases had sex trafficking as the primary offense, and in the both can include, for example, a massage parlor. This is reflective of not of what is most prevalent in reality, but what is more often being investigated.
So, go ahead.
No, go ahead.
I was going to say that this slide, when we were preparing for this webinar, is one of the most fascinating to me, because if I was to provide this group with a pie chart of the cases in my clinic currently, the pie chart would look the exact opposite, in that we are serving about 82% victims of labor trafficking and the much smaller slice of sex trafficking cases. And we find that we encounter in our work, huge numbers of labor trafficking victims, but the pie chart for which cases are prosecuted is much different. We have significant difficulties in getting prosecutions for a number of our labor trafficking cases, and so I think that we need to pay attention to those. I can share with you my own personal feelings about why I think we struggle despite fighting quite hard to get these cases prosecuted. And I'm really going to draw a distinct line. These are cases that are being investigated by law enforcement, and when they're brought to prosecutors are chosen not to prosecute because, I think there are sometimes cases that aren't investigated, but I'm really talking about cases that aren't prosecuted. And we find that we hear sort of 3 to 4 things about our cases when they're declined to prosecute. One, in our domestic servitude cases, we often get the sense that there's a feeling that one victim isn't enough, that for some reason there is a desire, or it could be a resource issue, to look for cases that have multiple victims. And then also in domestic servitude cases, it's often just a he said, she said case, or she said case, and therefore there's not enough evidence. On the complete opposite end of that, we have found in some of our cases that involve especially seasonal workers that the case is actually too large. It involves too many jurisdictions, and with seasonal work, the victims are moving around, and so investigating can be complex, and no one really knows how to take the first bite at the apple, if you will. We have worked with victims from the carnival industry for years in multiple states and have had no success in getting any of those cases prosecuted. And this summer, I'm sure, again, we'll start our next round of carnival worker cases. I think there's also sometimes an unspoken, but at times spoken even view that labor trafficking as a crime isn't as bad as sex trafficking, and therefore there's a belief that the case needs to be on the extreme end of labor trafficking to prosecute it, that we need to find force in order for labor trafficking cases to be brought. We know legally that's not correct, but we have to get over people's biases and assumptions. And finally, I think that unspoken amongst so many of us in the United States is that there is often an implicit acceptance that there are certain industries and certain populations where there are negative work environments. And I think there is a big question mark about where is that line? Is this just a crappy work environment, or is this compelled service and exploitation? And so I think we want to own, those cultural biases that we have about certain populations and the work they're exposed to in certain industries, so we can really figure out where that line is and make sure that when we see labor trafficking cases, we're treating them as such.
So why aren't we prosecuting more labor trafficking cases? Why isn't this happening? Even the Cook County Human Trafficking Task Force, which is one of our country's most proactive and experienced operational task forces with incredible prosecutors, investigators, and advocates working together in Chicago, did not charge a defendant with labor trafficking until November of 2013. We can't prosecute cases that we're not identifying, that we're not investigating. So we'll discuss some of the many reasons that labor trafficking cases are challenging to identify and prosecute, and then move to solutions.
So I identified before a few of the reasons that I think that these cases are challenging, and then we want to also realize that sometimes they're challenging because we don't see them as labor trafficking. They are categorized as something else. And just as we say, there's not a second chance to make a first impression, I find that in the trafficking world, there's not a second chance to redo that first impression of a case so often. And what that means is that whatever the snapshot was taken of that case, whether it's a wage and labor, a wage violation case, or it's an EEOC-based case, whatever that snapshot is, and it gets categorized within our criminal justice system, it is sometimes hard to expand that category to include labor trafficking. And so one of the things that I encourage people who are working on this issue is to try to press pause, if you can, on fully filling out that snapshot. If you can wait until you get some more information to truly see whether there's something bigger going on here, or to see whether these wage violations are actually labor trafficking, it will be helpful, because I just find that once we have categorized the case as something, we line up evidence to focus on that categorization, and we don't ask questions about other categories. And so it's not the case that we don't want to look to these other tools. It's wonderful, especially if we can't get enough support for a trafficking charge, to think about, can we go after wage payment issues? Can we use the EEOC? Can we use civil rights? Can we use other tools to supplement a labor trafficking prosecution? But we never want to think about excluding labor trafficking because we're doing these other things. The other reason is this slide shows that there's challenges in screening for labor trafficking is that it so often is the case that where labor trafficking exists, there's a co-occurrence of other crimes, as Vicki said at the beginning, including violent crimes such as rape. The other big issue in labor trafficking cases, since the majority of victims are foreign nationals, is the complexity of immigration issues that surround these cases. And that raises issues both for seeing these cases as labor trafficking, but also for victims' willingness to participate in an investigation and prosecution. Right now, when you take the snapshot of a case and what you see are undocumented individuals violating federal immigration laws, you're probably not going to think about asking questions that could support a labor trafficking claim. If you don't view someone as a victim, you're not going to try to find evidence that supports them as a victim. The other thing is, even if you are taking the snapshot that you view a case as labor trafficking, it doesn't mean that the trafficker hasn't instilled such fear in these victims and told them to lie about their immigration status or other things that they're willing to come forward. Also, many victims have already committed the crime of immigration fraud by the time you'll encounter them and see them as a victim. It's often part of how they come in to the United States, and many of them know that they did it. And so you'll have to make sure and assure them that this is not something that they're going to be charged with. The other thing you want to be aware of are cultural implications for foreign national workers. For example, we know of cases in the United States where, for example, in Filipino culture, there is deep deference to employers and what they ask, that even if someone didn't want to do something, they would feel compelled to obey because of cultural norms. In Nigeria, for example, before people are brought over to the United States, they're often bound to the trafficker through an oath ceremony with a native doctor. If you're unaware of those cultural realities, you may not identify or even see the compulsion aspect or the coercion. If someone feels bound by a ceremony that happened back in Nigeria, the trafficker may not have to do much in the United States to keep them coerced. And therefore, if you're only asking questions and gathering information about the behavior that happened in the United States, and you don't even think to ask about what happened back in Nigeria, and the victim doesn't disclose this ceremony, you may miss the exact thing that was compelling the victim to do the work. Okay. We want to think about screening tools. where is screening done and what are points of entry. Again, because of the co-occurrence of crimes, sometimes we know that people are in our systems for other reasons, and we're missing the chance to screen them to see if they're a victim. So who are we missing as we think about identifying labor trafficking cases? Well, in the work of the clinic, we find that one of the groups that we're missing are folks who, prior to being trafficked, are vulnerable because they are intellectually disabled. And we know that traffickers are targeting this population. So we're not doing a good job of screening for them, and we're not doing, even to identify them, and we're really not doing a good job of screening for their underlying issues to see if we can help them. What often makes someone so attractive to a trafficker to be exploited makes that person equally unhelpful, if you will, in a prosecution or investigation because they can't provide the kind of evidence we expect of someone who observes certain things or experiences certain things. That's not to minimize, let me tell you that the trafficking experience itself can create mental health issues, PTSD, and other kinds of trauma that we'll talk about later. But I'm really talking about folks who are already vulnerable from a mental health issue prior to being trafficked, and we don't account for that vulnerability in the identification, investigation, and prosecution. And then the other is that victims who are being exploited outside of work by their employers. So we had a case that we were never able to get investigated here in Michigan where a number of individuals from Eastern Europe were being brought to the Upper Peninsula in Michigan and forced to, on J-1 visas, and forced to clean hotels. And their employment contract had a fair wage rate and promised, I think it was like 20 to 30 hours a week of work. This all looked quite legitimate, and it was, except what was happening was they were getting paid that wage rate. They weren't getting enough hours at work, though, and the hotel manager required that for the women to work at the hotel and keep their jobs, they had to live in a home that she owned and rented out. There were upwards of 15 girls in the home, and the rental rate was outrageous. It was 10 times market value in that city, and the women did not even make enough money cleaning the hotel rooms in order to pay that, so they had to find outside work to keep paying that rental rate. And the investigator, when presented with all these facts, and he did the interviews himself and did it, he said, I see what you're saying, Bridgette, but I have to focus on the wage rate that they're paid, and they're not being exploited for their labor. Well, right, if you take the snapshot of only what happens in that workday at the hotel, he's right, but if he understands the compulsion that's occurring that's making them work there and that she's essentially making them work other places and handing them over all their money, they're clearly labor trafficking victims. But we're missing them because we are conceptualizing of labor trafficking as sort of a very what happens to you in this moment, in this location, and we need to understand the entire environment and the power that the traffickers have over the victims overall. Okay, we've talked a little bit about some challenges to identifying victims of labor trafficking. I also want to share these, which we haven't touched on yet. One is a lack of victim self-identification. There still exists in this country and around the world often an expectation that victims will self-identify. I often call it the white horse syndrome, the idea that if we could only find them, the victims would stand up, whether it's in their hair braiding salon or in the restaurant or wherever, and say, I am a victim of a severe form of human trafficking pursuant to, 22 U.S.C. blah, 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 please rescue me. I say that a little extreme, but, this expectation that they're going to self-identify as a victim is as unrealistic as if they will stand up and say what I just said. They don't do it for a variety of reasons. They're terrified. They don't believe that law enforcement or others are actually there to help them. They may have been told or believe that they already saw law enforcement complicit with their traffickers. Sometimes traffickers will set up situations where individuals who are dressed like law enforcement will come in and be friends with the traffickers. A victim may feel that their illegal entry into the U.S. means that they will be in trouble. They may not understand, either because of their own mental abilities or because of what happens in their home country, that's what is happening to them is wrong. They may also believe that what is happening to them is okay because the trafficker has brought them to the U.S. and they may, in fact, one day get a chance to live a better life. They may be very, very afraid of what could happen to their family back home if they share what is happening to them. They may believe that money is being sent back home, and so if they're stopped from doing what they're doing, even though life is horrible for them, that their family back home will suffer. I think this is really important to understand when you're doing this type of investigation, because I hear, I hear law enforcement very nicely and genuinely say to victims upon rescue, you are safe now, nothing bad is going to happen. And I think we want to be careful about saying these things, because often safety for victims includes safety for their family, and their family may not be safe back home. Traffickers are often very powerful back home and have abilities to harm family members even after a victim is already in custody in custody with law enforcement in the U.S. I just want to say it again, we have to stop looking at the actions, beliefs, and behaviors of the victims and put our focus instead on the actions, beliefs, behaviors of traffickers. Even if someone consents, doesn't take opportunities to leave, and doesn't self-identify upon rescue, lies, and has committed immigration fraud, none of those things mean that that person isn't a victim of labor trafficking. Okay, next slide. So why do we have such low reporting of labor trafficking victims? So there are several possible explanations. I'll be honest, I'm not sure any of these totally tell us why. One thing we know is that victims of labor trafficking are usually older than victims in sex trafficking. We know that they're predominantly foreign nationals, which means we have immigration issues, language issues. But what we also know is that in identified sex trafficking cases, that authorities only need to look at an industry that is already illegal. So this is where I think this is really the difference. We see data all the time on the number of sex trafficking cases that are identified, and of that data, only 13% of those sex trafficking victims were age 25 and older. So what that means is that we're predominantly identifying and prosecuting sex trafficking cases, and of those victims, that predominantly almost 80%, no, more than that, I can't do the math, predominantly are children. So why? Well, one reason is that sex trafficking occurs for the most part in most places within illegal industry. It's so easy for law enforcement to target those individuals. And what it also means, though, based on our data that most of these victims are kids, is it means that we're identifying victims that by law usually can't be charged with prostitution, or by law now, and often previously, but more often with safe harbor, can be charged. And so I don't think we should look to the sex trafficking numbers and say, we have that figured out. I think what that says is, we've figured out how to go into an illegal industry and have an entry point that way, and then identify children. Because what this doesn't show is of the adult victims of sex trafficking or of prostitutes, how many of them are we screening? And that's really what we have to figure out how to do in the labor trafficking situation. You can walk into a business, and some of the people in there may be victims of labor trafficking, and others may be legitimate employees who aren't being exploited. It's really hard to find entry points in the same way that we find in sex trafficking. I think that we should really ask tough questions about this, though, because there's a statistic that we found when we were preparing for this webinar that was really compelling to me. It said that between 2003 and 2009, so this is not the most updated data, but this is the last update we could find. The Office of Victims of Crime had said that almost 2,700 foreign national victims had been pre-certified, and that just means that's a connection to how they get some benefits. And the majority of those victims are labor trafficking victims. Now, if you are pre-certified and you're getting benefits, that already signals that you, if you're an adult have had contact with law enforcement and that you are willing to provide information. So again, these are not individuals who are refusing to participate. These are not individuals who are refusing to comply with requests. These are individuals who've had some sort of contact with an investigator, and that case, for some reason, not reported in this data, it's not going anywhere. And so I think we both need to figure out identification, but also why aren't we prosecuting cases that we have already identified and that are already in our system and are receiving benefits, both caseworkers, medical assistant, others, and immigration benefits within our system, but for some reason that's not connecting up with prosecutions.
So who should be handling labor trafficking cases? Federal statutes and almost all state statutes cover broad forms of human trafficking. So locals can prosecute trafficking cases, can prosecute labor trafficking. However, we know of no prosecutor's office or local or state law enforcement agency that has a unit or a person designated specifically to handle labor trafficking, while many offices now have a general human trafficking unit or have a unit specifically dedicated to sex trafficking or minor sex trafficking. Thus, many state prosecutors who reported that they weren't sure who would handle a labor trafficking case if such a case was referred to their office. And that's a significant challenge in getting these cases to move forward through the criminal justice system. The prevailing beliefs about labor trafficking, even among many who already work on trafficking issues, is that many prosecutors assume that labor trafficking would likely involve immigrant victims, and it often does, but not always. And thus, federal prosecutors would be in a better position to handle these prosecutions. Interestingly, we have been seeing more cases of labor trafficking that are involving developmentally disabled victims. And hopefully the fact that more of these cases are starting to be identified by law enforcement in some jurisdictions will spread to their identification in other jurisdictions. Notably, this has occurred in Chicago, and this has occurred in Philadelphia. The Urban Institute report and other anecdotal evidence points to some prosecutorial hesitation, some reluctance in handling and proceeding with labor trafficking cases. Think about these in comparison to what is happening in your jurisdiction. So the barriers included, there was no precedent or case law related to new human trafficking laws, particularly true for labor trafficking. And tellingly, one member of law enforcement reported to Urban Institute researchers, and this is a quote, "If you haven't done something, you aren't sure of it, and you really don't want to stick your neck out." And obviously there was a reluctance in that individual's jurisdiction. Particularly for labor trafficking, there was little institutional structure. Some of the offices studied were not even sure which unit or prosecutor would be assigned if a labor trafficking case did come through their door. These issues reached the highest level of decision-making officials because without their leadership, without their message to law enforcement and prosecutors that their office and their professionals should be handling these cases, they're not going to handle these cases the way they should be handled. Prosecutors also questioned who would have jurisdiction for labor trafficking cases, especially if the victim was undocumented. We're also, again, talking about a lack of training specifically related to labor trafficking cases. So even when jurisdictions are conducting and receiving training on human trafficking, often there is no inclusion of labor trafficking, or at best, 10 minutes dedicated to labor trafficking. And finally, this viewing victims as perhaps appearing to fact finders that they would seem to be incredible and bad witnesses. Other issues also contributed to prosecutorial challenges. And like most violence against women cases, the case is about much, much more than what happens inside of a courtroom. The victim must be supported throughout the entire process, or not only will that victim be less likely to make it into the courtroom, in other words, to trial, but we won't really be doing our job. Okay? Prosecutors are charged with seeking justice. So without considering all these other things, we're not doing our jobs effectively at all. Part of seeking justice is making victims whole, getting them linked up with resources, with housing, etc. The lack of these things, specifically dedicated to trafficking, to labor trafficking victims, is certainly a justice impediment. Regarding deportation, even though federal law protects trafficking victims, some victims with lack of resources have in fact been deported. Another challenge that ties into what we discussed in the previous slide is the use of what we're calling strengthened prosecution laws to prosecute traffickers. In one jurisdiction that was studied by the Internet Institute, rather than use the trafficking statute, a prosecutor used that strengthened prosecution law to prosecute a trafficker. And what does this all come down to? Some issues that were investigative challenges are, not surprisingly, also prosecution challenges. The Urban Institute study included several examples of comments, but one was from a judge who allowed in a lot of evidence at trial in spite of irrelevance. So when we're talking about lack of judicial awareness, this is certainly an example. In this specific case, the evidence included past arrests for prostitution. This was a real barrier that confronted a prosecution. This is something that we unfortunately see often in sexual assault cases, in intimate partner prosecutions, and certainly could happen in a labor trafficking case. We just saw an example of the admission of irrelevant evidence in a case that was reported in a large urban jurisdiction. Okay, so this was a rape case. In that rape trial, a judge allowed the defense to call witnesses to testify that the defendant had never raped them. This is beyond absurd, if we're speaking frankly, and we should. To provide an analogy here, okay, this would be akin to a defendant on trial for burglarizing your home, being able to call witnesses to say, oh, hey, I love that guy. He never burglarized my home, so he couldn't have burglarized yours, as if that is at all relevant to the issue of the commission of a burglary on your home. In a labor trafficking case, we might see a defendant try to claim, for example, that he didn't traffic another employee, and therefore that's proof that he did not traffic a victim in a current case.
Vicki, we have in fact seen this type of evidence brought in cases that I reviewed where employees that were treated fairly by the trafficker were brought up to testify and saying, you know, I went home at the end of the day, I was paid for all the hours that I worked. Their experience was real and true, but it doesn't change what was happening to the victims in that case.
Yeah, and this is really, I'm glad we're talking about this, because this is an example of the importance of prosecutors working with multidisciplinary professionals to get as much information up front as possible about including any potential defense witnesses. And this is a prime example of something that could and should be litigated out pre-trial. So even if the prosecutor is not specifically aware that the defense could be calling these witnesses, and any prosecutor listening to this webinar knows, about 5 minutes before a defense witness is going to take the stand, you could get notice that that defense witness is going to take the stand. And perhaps at best you would be able to get a break to get that defense witness's date of birth and pull any available criminal extract. So this is the kind of thing that even if we are not told before trial that the defense could be calling such a witness, we should be routinely filing a pre-trial motion in human trafficking and sexual assault cases, et cetera, to prevent this kind of defense testimony.
I think it's also important to know, I know this slide is about prosecutorial challenges, but I really want to take it back a step to investigation. You know, we have seen investigations not make it to prosecutions because when the prosecutor reviews the evidence, you know, there are 10 interviews from 10 non-exploited employees that say life is good for me at this company. And so, you know, we just want to be aware that just because life is good for 10 people doesn't mean it's not being exploitive for other people. So this issue has, huge impact on how cases are treated at every phase in the criminal justice process. The second point on the slide here, lack of victim participation investigation, even this framing alone implies that a victim has more choice than may actually exist. The victim may be too traumatized from their trafficking experience to really be able to participate in the investigation or prosecution. It may be too traumatic to walk back through what's happened. The victim may truly believe, based on direct or more subtle threats, that she has no choice, and sometimes that's due to the fear of the trafficker and what could happen to family members back home. We represented clients in a case that the girls from Ukraine were being forced to strip in a strip club, and they escaped and they were put in custody of the U.S. government. They were actually moved to Chicago in a safe house, and all the while being promised that they were safe, and the trafficker hired someone to firebomb their car. Now, you're not going to establish great trust with your victims because the victims kept saying, this is not a safe area for us. Our trafficker's relatives live here. He knows where we are. Those concerns were dismissed at first until the car bombing occurred. So I think we need to really listen when victims say they are scared. Maybe the trafficker isn't as powerful as they believe him or her to be so, but the fact that they are that scared is real and valid for the victim and will impact their ability and their freedom to participate in the investigation and prosecution. There's also issues of culture, which we've talked about, and then there's culture, our own culture, cultural relativism that we want to be sure to take into account. It affects investigators, prosecutors, me, judges, juries, all of us. I think that sometimes people implicitly feel these sorts of things. Well, it's more money than they would have made in their home country. Even though it violates our laws to pay them that little, they're still better off. They're better off now than they would have been if they stayed at home. This is what happens to those people in those countries. We've actually seen these types of defenses made by traffickers in trials that, there's a domestic servitude case out of Michigan where the trafficker, claimed that on the stand that this girl was better off than her home country, so it was okay what was happening to her. Now, judges and juries and prosecutors wouldn't put those sorts of things on the record, but we want to make sure we're checking those assumptions. It's the same type of issue when someone who is undocumented is called an illegal, and that their status of being here illegally somehow diminishes their victimization. We see that happening in cases lots of times, and we need to account for that. Just because someone has done something against our immigration laws, whether voluntary or not, should not be held against them, and they should not be viewed less as a victim. As I've said before, there are issues of identifying these cases because they often occur in legitimate businesses. It's very hard to target. You don't have, many police forces have a vice squad. You can't have a restaurant squad and a farm squad and a hair salon squad. So, you couldn't, you don't have the personnel or the focus that vice squads have. So the scope is huge. And as we've said already, that sometimes employees are treated well, and when there's a mix, it can be really hard to get the evidence you need for the prosecution.
Right, and that good treatment of certain employees could absolutely be by design. That could be the trafficker's plan all along. A lot of them are very sophisticated, and they're planning for possible law enforcement identification or another agency looking into their business practices. So that could be by design, and it could also be a situation where we're looking back on slide 22, or we're thinking about other reasons, these particular employees are unable for one reason or another to identify as victims of trafficking, and the statements that they have given saying this person has treated me well as an employer, et cetera, are not actually what's happening. And the final thing on this slide is about juror perception. And certainly another prosecutorial challenge is the perception that our jurors have, that they may be fixated on the idea that slavery involves what we have heard historians and family members talk about and what we have viewed and seen pictures of. In other words, slavery includes physical chains, total lack of rights. Slaves came here in a decrepit shipping container, ideas and images along those lines. And therefore, prosecutors will have to determine how to handle the involvement of psychological coercion, whether it is or is not combined with other methods of control over the victim, and then explain that to jurors so that the jurors can understand those other mechanisms of control. And where do we do this? We do this as much as possible during voir dire, during jury selection, so that we can understand if jurors are coming into this trial with certain biases, with certain misconceptions, and then we take that, we establish a theme, we stay offender focused, and then we have to keep that message on point throughout the entire trial, and then, of course, big time bring it up and have that be the focus of our closing argument.
Okay, so what are some strategies for doing these types of cases? Well, very few, if any, trafficking-related solutions need to be created from scratch. You'll be solving your jurisdiction's issues by seeking out information, finding out what others are doing it, adapting it, and then implementing it in your own area. And if I could just give one word for how to think about strategies on these cases, it's collaboration. You know, we in the Human Trafficking Clinic represent victims of labor trafficking all the time. Many times we are unique because in other cases where victims are involved, they don't have their own lawyer. And at first, and many times, prosecutors, law enforcement aren't sure what to think about having this extra lawyer at the table. And we have heard in the past that they weren't excited about the victim, quote, lawyering up. I understand that inclination. I know that more people at the table means more time, but I really hope that if you're in a jurisdiction where you have a law clinic nearby who's willing to do this work, or other pro bono attorneys, or you can find victim advocates for victims of labor trafficking, it has, and I know prosecutors I've worked with and law enforcement I've worked with would say, when done well, it makes cases so much more successful because victim needs are able to be addressed in a much more comprehensive manner. And often victims of labor trafficking have legal needs that have nothing to do with the prosecution, and they often need to be taken care of from the victim's perspective immediately. And so if you can pass that on to another lawyer who can work in the victim's best interest and focus on the prosecution, and then have the victim, when they're with you, focus on the prosecution, everyone gets their work done better and the victims feel supported. So I mentioned the promising practice if you have a clinic in your area. If you are in the Midwest, or even if you're anywhere in the country and would like to talk to us in the Human Trafficking Clinic and see if there's something we can help you with, we're happy to do so. We work cases in a variety of places, sometimes because we're the only lawyer who will take the case on. But you can look around for, professionals in other fields who understand these populations who might be willing to collaborate with you. I'm sure participants on this call have other suggestions for promising practices. You want to think through, if your jurisdiction doesn't have one, a task force, but I can't stress this enough. If all you have on your task force are law enforcement and prosecutors, you won't get the results that you want. We bring a number of cases to law enforcement because victims come to us through other places, and if we didn't have the type of relationship that we have with law enforcement and prosecutors that we built through our task force work, and our task force is not funded, it's not one of the government-funded ones, we wouldn't feel confident in bringing cases to them. And so it's really the relationship building that will even get you more cases. And so you want to be proactive in your investigations, do appropriate charging. And the other thing is clarity in messaging. I can't stress this enough. If you are doing this work, be clear in your messaging, and this is an issue that victim advocates have as well. My skin crawls when I hear someone say they're talking about human trafficking and they're really only talking about sex trafficking. And it happens more often in this way. We say human trafficking and we really only mean sex trafficking. Don't say human trafficking and then only give sex trafficking examples. Make labor trafficking a specific part of a conversation if you're going to have a conversation about human trafficking, or just have a conversation about sex trafficking if that's really what the conversation is about. Make sure your partners and collaborators speak with the same clarity. Numerous times times in my work I will be in a room where someone will stand up and say that they have either established or plan to establish a shelter for victims of human trafficking. I then raise my hand and say, will you take a man who's been exploited in a restaurant? And like, well, no. And I was like, well, he's a victim of human trafficking. Well, no, we only take U.S. citizens. Okay, so will you take a U.S. citizen male? No. Okay, and then you unpack it and you realize that the person who just stood up and said they have a shelter for human trafficking victims really has a shelter for U.S. citizen girls who are victims of sex trafficking. I am not saying it's not important to have shelters for U.S. citizen girls who are victims of sex trafficking. What I'm saying is if you tell a room full of people that you are a resource for a broader group than who you're actually a resource for, they're not going to call you the next time at 2 a.m. that they have a need because you haven't been helpful. And you push the movement back to try to find good resources for victims because people say, oh, we have 7 shelters for human trafficking victims. We don't need more. When in fact we don't have any shelters for labor trafficking victims, or we don't have any shelters for foreign nationals. So I just think clarity in messaging is so crucial, in addition, to doing the training and collaborating and being proactive. But we need to be clear in our messaging. Okay, and we covered some of these already. Okay.
And one thing I just wanted to mention also about the importance of the task force, and I think we talked about this later in the webinar, but it's so important, not just for the wonderful reasons that Bridgette already mentioned, but for reasons of your case and also for reasons specifically related to supporting the victim. And those could actually be the same. And a clear example of that is if law enforcement is not working, whether it's on an official or even unofficial task force or have an individual relationship with someone from the Department of Labor, the Department of Labor may have no idea that there is an open law enforcement investigation. And so while law enforcement are perhaps hopefully working with advocates, getting this victim interviewed, providing services, et cetera, the Department of Labor could very well unknowingly go out and take 1, 2, 3, 5 statements, not only from the victim, but from other potential victims, witnesses, and defendants in this trafficking enterprise. And not only are these multiple interviews potentially damaging to victims and witnesses in terms of causing additional trauma, but they 100% could cause significant complications in the ability to investigate and then certainly later prosecute a case. So that's just one example of the importance of having these multidisciplinary professionals work on a task force together. Everything that we do for these cases has to be victim-centered, and that's the awareness of the central role that victims and survivors play in the process. And by process, I mean the entire process, the criminal justice process, from the second that the survivor is identified by anybody, and consideration of the survivor's safety, privacy, and well-being throughout that entire process. And we've got to work together to ensure access to services and to information. This is not just trafficking cases. This is all violence against women cases, all cases in general. Offender focus is acknowledgement that offenders purposely, knowingly, intentionally target victims whom they believe they can successfully exploit. And so by proceeding in this manner, we are keeping the focus on their actions, behaviors, characteristics, and intent. And so often, unfortunately, this is not the case, not only in society, but unfortunately in our own allied criminal justice professional circles, that when these cases come to light, so often the first questions that are questions of perhaps skepticism, eyebrow raising, are focused on the victim. And this is a practice that has got to change because A, it's wrong, and then B, we get to trial and our jurors can certainly pick up on this. It's apparent in testimony, it's apparent in language utilized in reports that are generated by us. It's got to change.
So who needs training? I know that we are starting to run out of time, so I'm going to pick up my pace a little bit. So this chart lists just a handful of people who need training. I want to point out the administrative agencies. One of the things we've talked about is that we need to figure out other doors and access into these industries. Think about who's inspecting, who's licensing some of these industries where we think of labor trafficking as being common. We've seen jurisdictions use these types of administrative areas of law as ways to really get at labor trafficking situations. And so don't forget about some of the sort of less sexy areas of law than sort of, that we might not think of right away, but can really have a significant effect on identifying cases.
So technology and social media, as we all know, are becoming bigger and bigger and bigger part, not only of trafficking crimes, but of so many of the crimes that are committed in society now. We've got to have a better understanding of technology, of pretext calls, of wires, of how to employ those in investigations, how they impact investigations, how they're used to facilitate crimes, and perhaps how traffickers then deliberately avoid using some of these things in order to commit crimes. So the bottom line is we've got to merge those basic, solid investigative techniques that we've always utilized with emerging technologies to put the case together. If we want to be able to fight trafficking, we've got to be up on the technology and pull all of the things together in the slide, but then be one step ahead. We've got to also try to provide law enforcement with the tools to access big data, so they can start to do additional things like look for stolen and lost travel documents, get international background checks, cross-check all of this, and then start to identify patterns in criminal behavior. They've got to access password-protected devices, use tools that provide for data mining, mapping, computational linguistics, advanced analytics. Google has actually done a lot of work in this area. There have been some really great articles and other projects that are exciting and that are intended to help law enforcement stay a step ahead of traffickers. But in the meantime, we've got to be focusing more on technology.
I think we also need to focus on how victims perceive technology to be used, whether that's accurate or not. We had a case where the victims believed that a webcam set up on a computer was monitoring them all day, even though the webcam didn't have that capability. So again, understanding both how traffickers are using it, or how victims are perceived that they're being observed, because that was a key piece of evidence in the case. The children believed that all day long that the trafficker could see them and know what they were doing. So we've talked a bit about these multidisciplinary task forces already. They exist. There are at least 42 of them around the country that are sponsored by the federal government. Like I said, Michigan, we have one that's not sponsored. But again, this is about not reinventing the wheel. You want to ask around if your state already has one or multiples, and local agencies may already have resources on this so that you can get up to speed. And there may already be some folks who have already identified places where victims can go and that sort of thing. If you don't have one in your area and you're thinking about setting one up, please feel free to reach out to me. There are some things you want to think about before you set one up, about clarifying roles, managing information, that sort of thing. I'm happy to help anyone who wants to do something like that.
And we have another feedback question just asking whether or not your jurisdictions have an agency that's dedicated specifically to labor trafficking, and you can use the feedback indicator on the left to choose yes or no. And you can also private chat me what that agency or, other organization that deals specifically with labor trafficking is. And it does look like the majority of folks on the webinar don't have a specific agency dedicated to that, to labor trafficking, so far as the responses are coming in.
Okay, so we want to think about ways to go about investigating labor trafficking. It seems like one thing might be to figure out the organization that would be dedicated to that, or at least have that within its scope of work. So that's probably a good task for all of us to think about that. But let's look at ways that we can be proactive in our investigations. In an Urban Institute study, the challenges experienced in jurisdictions included a lack of cooperation, which we've talked about, that maybe that's not possible, that law enforcement was unprepared for what interviewing trafficking victims might be like, specifically that untrained investigators weren't prepared for victims to recant their stories, inconsistent statements, and therefore might not have passed the case on because they felt that these inconsistencies and recants made it not a strong case. While this necessarily wasn't the case for trained investigators. The study also found that human trafficking victims needed services for longer, and police did not know how to, or didn't know this or didn't anticipate it. And the police often viewed arresting victims as a method, for example, of detox, because they were separating the victim from the trafficker. Police have said, for example, we don't want to arrest, but we don't have any other place to put the victims. There aren't shelters or other things available. The study noted, and I'll just say for myself, I agree with this in my work, that the repercussions of arresting victims are severe. If a victim is arrested, it will affect her ability to see herself as a victim and to cooperate in the future with law enforcement. In fact, this is not from the study, this is from my experience. Traffickers will often say, this is what will happen to you if you encounter law enforcement, you will be arrested, and if they are then arrested, it simply reinforces the knowledge, power, and control that the trafficker has over them, because the trafficker said, this is what would happen, and this is what in fact happens. Jail can be a very dangerous place. Credibility is challenged. Prosecutors often in trafficking cases require more than one victim. We see this all the time. The study found that law enforcement would bring cases forward and would get resistance from federal or state authorities. They wanted multi-victims or multi-defendant cases, or only wanted domestic minor sex trafficking cases. We really, really need to turn this around. Let's think of how we can get to those other identification points before we have a victim who enters the system through, for example, arrest for collateral crime, or as a historical victim, meaning the possibility the labor trafficking was identified by someone in the system, and then law enforcement investigates, and either the trafficker has possibly already left the jurisdiction, or a victim perhaps is missing or simply can't be found by authorities. We can think about proactive policing, reviewing ads and visa-related postings, investigating companies that connect international students with universities, looking at Craigslist articles about J-1 visas, migrant labor. That example I gave earlier in the webinar about the J-1s in the Upper Peninsula of Michigan, J-1s are not supposed to go to places where where there are issues of employment and take jobs that Americans should have. Anyone who understands the economy of Michigan would question why were those J-1s issued for those placements. So, we know that there are some issues with our visa system, and so anytime we see groupings of J-1 or other visa holders who are taking those types of temporary seasonal jobs, those really should raise some question marks. We want to cross-train agencies, have them work together. For example, if your jurisdiction has a beverage control bureau or other similar licensing or inspection agency, work with them to ensure they're trained and they know to call in police if there are signs or indicators. Too often we think about seasonal work, always think about our agricultural. We see it in landscaping, as I said before, carnivals. So we really want to, lifeguarding. We actually know of some J-1 visa issues around people who are brought in from Eastern Europe and forced to be lifeguards. The next slide talks about something that could be its own hour-and-a-half webinar, and so I really hope folks can remember this and incorporate this into their work. We have to. It is essential that we implement trauma-informed practices. Trauma impacts how victims behave. It impacts memory. It impacts their willingness to participate in an investigation. And all the things we might make assumptions about someone, what they would remember, how they would talk about something. When we add trauma into it, it changes what we should expect. And so if we don't understand that, we may perceive someone to be lying when in fact their responses actually reinforce that they were exploited in the way they claim to be, because their answers show that they've experienced a significant amount of trauma. Sometimes that means that we're going to have to bring forth experts to testify in a trial about trauma. We just have to be trauma informed. Work with experts. Make sure that your jurisdiction has identified experts you can use. We in our clinic have a trauma therapist to help us understand what's happening with our clients and help the people we work with understand it. You have to collaborate on this issue, but I can't underscore this enough that if you're not thinking about trauma when doing these cases, you are going to miss victims and fail in some prosecutions.
And trauma will often manifest itself in a way that a victim is unable to generate narrative memory that we can normally muster from an important experience. So they're fragmented, out of sequence, filled with gaps. And rather than view this as perhaps an indication of questionable credibility, this should be something that absolutely ends up almost corroborating the other evidence that we are finding in these cases. Of course, somebody who is trying to recall this information has experienced trauma and perhaps is additionally traumatized at the thought of having to share the information is going to have some of this evidence. Intelligence gathering, which is we're looking at the first line of this slide, it really allows law enforcement to collect, organize, analyze information about an actual or potential target, or just provide general information about activity in an area or another subject. And this information is crucial. It may not only help build evidence against a target, but it could also assist in other criminal investigations. This is all about proactive policing. When we're talking about preparation, if you want to be able to gather evidence, you've got to do foundational research. We can learn more going forward by knowing more at the outset. So do as much reading of documents, talking to others familiar with the case as possible. It may help the victim feel supported and thus help the interview if somebody else is present, including an advocate. But tread carefully here and ensure that anyone present is fully vetted. Do not conduct an interview in the presence of any other potential victims, caretakers, relatives, or, of course, potential suspects. When possible, prior to an interview, also try to lay the foundation for future interviews, not only in terms of background knowledge, but this is where advocates, survivors, cultural experts, etc., can really be an invaluable resource to the investigator gathering information. And then also think about corroborating down the line. So establish connections between the trafficker and the victim and victim's family. Definitely monitor all jail calls, jail visitors. Listen to those calls. Read all communications. See who is visiting whom in jail. Any of the visitors could be potential victims or co-defendants. Reach out to corrections officials to find out what the defendant is doing in jail, who he is hanging out with in jail. Perhaps he has started a trafficking network in jail, or trying to build upon, continue to recruit for his existing outside trafficking enterprises. We've got to be looking at the totality of the circumstances always, and of course, this includes interviewing the defendant. The defendant, if he or she is not going to give us the golden nuggets that we're hoping for, the defendant may be able to corroborate other things that are going to help us build the case. Law enforcement should always attempt an interview with the defendant and should write down every single thing that the defendant says. Everything. I'm talking even about during transport, while awaiting his interview, because these things may be admissions. They may help us corroborate a detail later. Of course, you need to Mirandize prior to the taking of a statement, okay? But the other things that the defendant says prior to that time should be documented so that we collectively can review them later and determine perhaps they will be relevant. If they can't come into evidence, then that will be determined during pretrial motions that that's not going to be admissible. But regardless, these are statements we want to be able to read, have access to, and know about.
So we talked about this already, but we just want to reinforce it. Do not penalize victims for risk-taking or collateral criminal behavior, meaning we have to keep in mind what our jobs are, what's going to be the best way for us to proceed, so we're holding the offender accountable and preventing future victimization. When there is a case, for example, of a sexually exploited woman, a woman in prostitution who is raped, we do not even want to consider arresting her. She is a victim of a violently heinous crime, period. There are similar situations that arise in labor trafficking. In fact, all of the bullet points on this slide are crimes that my clients, my labor trafficking clients, have either committed or been forced to commit immigration fraud, drug possession, use as a drug mule, theft. One of my clients who was held in domestic servitude was actually encountered because she was stealing food from a local grocery store to feed herself. Recruitment and smuggling. Often when victims are brought to the United States, they're forced to pose as a sister or brother of someone else, and then lie about who that other person is and could technically be charged with migrant smuggling. We don't want to penalize victims for this, and I would argue even more importantly, we don't even want to threaten that they can be penalized. I have seen way too often in interviews investigators or prosecutors say things like, well, you could have been charged for X, whether it's possession, theft, recruitment, smuggling, immigration fraud, but we aren't. You know, you may be saying that in good faith to let that person know they're off the hook, but what they hear is, I see you as a criminal, and I could be in trouble. You don't even want to threaten it. Arresting victims is not a solution. We must support them. It's harmful to the victim's psyche and well-being, and to your ability to prosecute your case. We want to think about alternatives to arrest, family reintegration, and safe options for the victims. Can you change the slide, Vicki? One of the most important things that I can share with you in this webinar is that there's a tool out there, if you're unaware of it, for foreign national victims who have been victimized for labor trafficking, that they can, if they meet the criteria, stay in the United States and be safe. And so traffickers use that as power over victims, that they will be deported. But the fact is they don't have to be deported, and very well may be able to remain in the United States for the rest of their lives. And so the two visas that we think about most often, not saying that there aren't other forms of immigration relief that could apply in cases, are U visas and T visas. T visas are specifically for trafficking cases. U visas are for victims of crime, including trafficking. Both visas require compliance if you're an adult with reasonable requests of law enforcement. Children can apply for the T visa without that evidence of compliance. Law enforcement has a role. They have to sign off on a document signifying cooperation. Note that prosecution and investigation are not required to sign document of support. And so we hear too often people say, well, I can't sign that document until the prosecutor files charges, something like that. That is not what that document says. It says that you have cooperated and that you've been truthful. And so, again, don't use your role in this process as a threat. There's a link here that on the bottom of the slide where you can get more information about these visas. Another form of relief that I might argue is even more powerful, especially in the beginning of investigation, is something called continued presence. This is for trafficking victims. It's a temporary immigration status. It lasts for 1 year. It can be filed immediately after identification. It can only be filed by federal law enforcement or a U.S. attorney. And so this is where it's so crucial to have those pre-existing relationships to be able to collaborate with federal law enforcement. It lasts, and you also get a work permit, and you can have access to some benefits. This can change the game for victims, both in their ability to start a life for themselves, but also in their ability to not be stressing about housing and work and food and survival, and allow them to more fully participate in the prosecution and investigation of what's happened to them. And so if you're not aware of continued presence or it's not happening in your jurisdiction, figure out a way for it to happen, because this is the game changer in so many of our cases.
So prosecuting labor trafficking, before we move into this, I just want to remind our prosecutors that the defense is absolutely not entitled to U visa application, that document, in discovery. So if there are defense requests for that, you should be absolutely fighting those requests. So in terms of interviewing, this is going to be the first opportunity of the prosecutor to have contact with the victim. And sort of as Bridgette said earlier, this first contact is so crucial. It's a different kind of interview than a law enforcement interview. Really, we're looking to build that rapport. And in terms of location and a lot of these other issues, we want to give the victim as much choice as possible. We don't want to be sitting behind a desk looking stiff. We want to be open and we want to be relaxed and encourage communication. Make the victim as comfortable as possible by having people there who are going to support the victim, like an advocate. Provide bus tokens or other transportation. But keep in mind that we've got to be concerned for victim safety. So the trafficker might frequent certain buses, subways, or stations, so we want to avoid those things if we think that the victim could be in danger there. Have water, have a snack available, and be clear about your role. Explain that a prosecutor is not the victim's lawyer. Explain what the prosecutor's job is, that the prosecutor works for the state, works for the government, that the prosecutor's goal is to be victim-centered and support the victim and to try to convict the defendant, to hold the defendant accountable. Acknowledge that the goal that a victim has may not, at this time or at another time, match the prosecutor's initial goals. And also remember, in terms of immigration concerns, that if those concerns aren't resolved, the interview could be unproductive or could face other challenges. As far as witness intimidation, we just want to stress, because there's so little time left, that this has got to be talked about specifically with victims as soon as possible. We have got to explain to victims what kinds of behaviors constitute witness intimidation, because so often intimidation is more subtle or has been going on for so long that a victim doesn't realize that it's intimidation, that it's a crime, that it's chargeable conduct, and therefore the victim won't report it to us. So we've got to talk to victims about intimidation that stems not only from the defendant, but the defendant's associates, and talk to the victim about how he or she can safely report it to us or to someone else, so that the intimidation can be addressed. It's going to be addressed as part of the trafficking case. We could charge it separately. We could bring it in under other evidence theories, but we have got to be explaining to victims what intimidation is and how they can safely report it. And directly tied to that is our ability to proceed via forfeiture by wrongdoing. So speaking of intimidation, prosecutors are, of course, always thinking about the availability of witnesses at trial, and we've got to be thinking more about the defendant's efforts to intimidate and retaliate against our witnesses and our victims in order to prevent those victims and witnesses from testifying. So 804b6 covers this. Forfeiture by wrongdoing applies to statements by a declarant who is unavailable at trial due to the defendant wrongfully causing or acquiescing in the wrongful causing of the declarant's unavailability. So in short, in cases where the defendant intimidates a victim or a witness or otherwise prevents her participation in the trial with the intent of preventing her participation in the trial, the defendant may be found to have forfeited his right to confront that witness at trial. So in these instances, prosecutors may introduce that witness's prior out-of-court statements or in-court statements, for example, those testified to at a preliminary hearing under this forfeiture by wrongdoing doctrine. These statements, coupled with the corroborating evidence we've discussed already, can provide prosecutors with evidence sufficient to prosecute labor trafficking or other cases, even when the victim is unable or unwilling to participate at trial. And there's a whole body of case law related not only to forfeiture by wrongdoing, but other criminal cases that have preceded some of these cases. Equitas has a lot of resources related to this, and we welcome you reaching out to us for additional information on this. In terms of establishing a defendant's guilt, we want to be looking at all the things that are on the slide, but we also want to be considering other crimes evidence that is covered under 404B. And this can notably, really importantly, include charged or uncharged conduct. And this is why, again, we want to be as comprehensive as possible in gathering statements, in gathering evidence. Another important thing to think about at trial is introducing expert testimony on victim behavior. All jurisdictions allow this kind of testimony in some form for at least one kind of violence against women case, whether it's intimate partner violence, sexual assault, trafficking. So This testimony will allow an expert to testify to commonly seen victim behaviors in order to provide a context for jurors to assess evidence that often may appear counterintuitive to them or would otherwise be met with deep beliefs about what constitutes appropriate victim behavior or victim blaming. And this testimony can be crucial evidence in providing a context to assess a victim's reaction to the trafficking and to assess the victim's credibility. I know that we're running short of time, but this is another subject, expert testimony and victim behavior, that we have additional resources on and you can absolutely contact us about. We've already talked about supporting victims. We don't want to forget about asset forfeiture and restitution in these cases, all of which should be contemplated as soon as a victim is identified. And also holding businesses accountable. This is another example of when working with others in your jurisdiction, including those on your task force, to hold offenders accountable could lead to holding businesses accountable. And all of this not only could improve practices in your community and around the world, but certainly help provide restitution and other forfeited assets in a trafficking case. We included a slide on the Urban Institute study that we mention very often. I encourage everyone to read the study. It's available online. There are many things available in our library, and I will pass this to Charlie to wrap up. Thank you so much to all of you for participating, and a huge thank you to Bridgette Carr for her knowledge, her kindness, her willingness to share this information, and being an absolute pleasure to work with as we developed and presented the webinar. Thank you, Bridgette.
Thank you for having me.
Thanks so much, Vicki, and I just want to let everyone know that when you exit iLink, we do encourage you to visit our website at equitasresource.org, where you can register for future webinars and training events and review additional information about Equitas and access a lot of those resources that Vicki was talking about just now. You're also going to be receiving a link following today's webinar to a SurveyMonkey evaluation, as well as a copy of the PowerPoint presentation and a full biography for Viktoria and Bridgette. And if you, there'll be information included in that email regarding CLE credits. Please follow up with any questions you might have. And thank you again all so much. Have a great weekend.